The second part of this module, part 2, is rules controlling the eminent domain process. We've divided the rules into state of Ohio rules and federal rules, and we are first going to go over state of Ohio rules, which starts with the Ohio Constitution, Article 1, Section 19. You have to pay for the part taken if it's taken for a road for public purpose. Second rule is from the Ohio Revised Code, Chapter 163, and that is the eminent domain code in the state of Ohio. And compensation includes the value of the part taken plus damages, if any, to the residue. The third rule is from the Ohio Jury Instruction for eminent domain takings. Ohio Jury Instruction covers a wide array of issues, but some of the more common ones is it defines compensation, it discusses highest and best use, it talks about the amount paid for PRO, which is an acronym for present road occupied, it talks about damages, it talks about minimization of damages, which is cost to cure, and it also talks about temporary construction easements. The fourth rule is the Ohio Administrative Code, acronym is OAC. And Chapter 5501, 2-5 of the code governs the Division of Highways, which is the Ohio Department of Transportation. Some of the things covered in the code is no negotiations until the property is appraised and compensation is established. The offer includes compensation for the part taken and damages, if any, and to the remaining property shall be stated separately. Appraisals can be waived under certain conditions. ODOT can develop appraisal standards for low-value simplistic issues, and the appraiser shall disregard project influence, and finally, all appraisals shall be reviewed. The next rule is Supreme Court of Ohio decisions, and these decisions have the same effect as law. We're going to look at one particular case, and that's known as Schaefer v. Sowers. And in that case, it's very clear that the value of the whole property must be considered before the taking. And the property must be valued as a whole. If there are several interests or estates in the real estate, the proper method is to determine the value of the property as a whole with a later apportionment of the amount awarded among the owners. Market value cannot be determined by separately valuing each part and component and then adding the separate values to arrive at a market value of the entire property as a whole. A little later in this presentation, we're going to go into more detail between what the whole is and what the larger parcel is. Also, case law governs what we do in eminent domain. And these are lower court or appeal court decisions that provide rules and guidance on compensability, processes, and other matters regarding eminent domain. And one of the bigger case law decisions is Masheter v. Keeby. And in Masheter v. Keeby, it's very clear that we must value the property before and after the take, that it's improper to permit a witness to testify as to the value of the land taken, but a qualified witness may give their opinion as to the value of the entire property before the taking and as to the value of the remainder property after the taking. And after so testifying, the witness may make an allocation as to the value of the land taken as part of the entire tract and damages to the residue. The seventh rule is the real estate manual for the Ohio Department of Transportation. As a condition for federal funding, ODOT must have a real estate manual, and it shall describe the functions and procedures for all phases of the right-of-way program, including appraisal review, and that comes right out of 23 CFR. The appraisal component of that real estate manual are sections 4,000 through 4,500 of the manual. The real estate manual discusses a wide variety of things, and anybody who does business with the Ohio Department of Transportation is going to have to comply with that real estate manual. But in particular, the appraisal types that we do at ODOT are discussed in the real estate manual. The first one I'm going to talk about is the waiver of appraisal. And it's implemented by the value analysis report. Compensation has to be less than $10,000. Valuation problem is simplistic. No review is required. And because it's under the waiver of appraisal provision, it's not considered to be an appraisal. The next appraisal format are appraisals of low-value simplistic valuation issues. And that is allowed under the Ohio Administrative Code that governs the Ohio Department of Transportation. We implement this with a report called the Value Finding Report. Compensation has to be less than $65,000. The valuation problem has to be simplistic. Appraisal review is required in this because it is an appraisal. And finally, that appraisal report must be compliant with USPAP, Uniform Standards of Professional Appraisal Practice. The last appraisal type we're going to talk about are appraisals for high dollar amounts and complex valuation issues. And the appraisal template we use for that is called the right-of-way appraisal report. And we use this when the compensation amount is not limited by any number, so compensation is unlimited. The valuation problem is complex, meaning there are going to be damages. Because it is an appraisal review is required. It also has to be USPAP compliant because it is an appraisal. And finally, this template values the property in the before and in the after. All right, we've already talked about the state rules, so let's talk a little bit about the federal rules that govern eminent domain appraisal process. ODOT's highway projects are funded in part with highway trust funds, and these funds are managed by the Federal Highway Administration, FHWA. The use of these funds require compliance to federal rules and regulation, and a listing of some of these are as follows. The Fifth Amendment to the Constitution of the United States, last clause of that says, "Nor shall private property be taken for public use without just compensation." Next is the Uniform Act. Uniform Act was passed into law by the United States Congress in 1971 and was codified in 42 U.S.C. Chapter 61. Generally, all federal agencies have to follow the Uniform Act when acquiring real property, and that act is amplified by 49 CFR Part 24. Third, FHWA is governed by 23 CFR, and 23 CFR Part 710 specifically governs real estate functions. That portion of the code was last updated in 2016. FHWA administers the highway trust funds used by ODOT to plan and design its projects, to buy rights of way needed for its projects, and to build the projects. And the use of highway trust funds in a project requires real estate to be acquired in compliance with the Uniform Act, with 49 CFR Part 24, and with 23 CFR. Next, we're going to talk about the Yellow Book. The Yellow Book is also known as the Uniform Appraisal Standards for Federal Land Acquisitions. This book was recently updated in 2016. It establishes standards and principles for legal requirements and practical applications for appraisal of property for federal acquisitions. 49 CFR 24.103 allows agencies like ODOT to supplement their appraisal standards with the Yellow Book. USPAP, Uniform Standards of Professional Appraisal Practice. This was developed by the Appraisal Standards Board, which is part of the Appraisal Foundation that sets congressionally authorized standards and qualifications for real estate appraisers. USPAP addresses ethical and performance obligations of appraisers, and again, 49 CFR 24.103 requires appraisals to be consistent with USPAP. Okay, it's time for a knowledge check. Please answer the following questions.